All right, we have a small crowd today here. All right, the classic album of the week is a double album called The Strawberry Statement. This is from a 1970, this is the soundtrack to a 1970 movie. Has anybody ever heard of this movie? Yeah, this is an incredible movie. This is a movie about the protests during the Vietnam War. It was based really on the student protests in 1968 at Columbia University. And it's set, the movie is set in a, actually it's set in California, in Central California. And it is at a fictional college there. And, you know, they have this revolution and it's a, you know, he falls in love with this girl and da-da-da-da. But at the end, you know, the National Guard come in with tear gas and, you know, the whole thing. But anyway, it is a, it's really a classic movie. You should do that. But the album itself has a bunch of really good tunes from Crosby, Stills and Nash are sort of the dominant, but Buffy St. Marie and Thunderclap Newman. There's a song called Something in the Air that you might want to, you really want to listen to this, the song Something in the Air, because it's you know, it's about revolution and you know, protests and all sorts of things. And I don't know if you've been following, but there were protests going on here not too long ago, right? Places like Portland and et cetera. So anyway, it's sort of interesting to look at, you know, back to 1970 movie that looks a lot like what's, in some ways, what's going on. And anyway, listen to Thunderclap Newman, Something in the Air. All right. So again, review session is on Saturday. I will attempt to Zoom it. There won't be a recording of it as you, Professor Butter is going to be out of town. But anyway, I'm going to attempt to Zoom it, and I will, if it works, I will try to send out a link. Now you can Zoom in. Now remember that you can come in with the meeting ID password, you know, which is my you don't get invited, right? You just get on and 517, you know, my office phone, 517 blank, and I've sent this out and it's in the server, or on the server. It's in the folder, but it's 517-607-2376 with the blanks in between. And the password is just Wolfram with a small w. And you can get in and take a look at the Zoom. And then, like I said, Zoom stores it in the cloud for, I don't know, 90 days or something. But anyway, I will send out the link so that you could, if you weren't able to get in during the Zoom time, there'll be hopefully there'll be a recording of it and you can take a look at that, okay? Otherwise, we'll be in here and on Saturday. And we'll basically just have an opportunity for you. Again, the exam questions are going to look, it's going to be 5 multiple choice, 5 true false, 4 essay questions, all 10 points. It's going to look a lot like, the essay questions are going to look a lot like either the old exam questions. I put 2 old exams in there, and then I have sample questions from chapters 2 through 5, and then I also had some additional sample questions that I put in there. So you have seen most of the exam already, okay? So if you have any questions on that, we can talk about that. We'll just do a little bit here, and if you have, in fact, what we can do now, has anybody looked at that and had a question on any of those things right now? I haven't been looking ahead. Okay, so anyway, just sit down with your notes, sit down with a book, and, you know, write out your answers so that when you walk into the exam, you're not going to be surprised. But it'll be easier to do the exam if you've thought through, made an outline in your head what the answers to the question are, rather than looking at the question and going, oh, okay, I know what that is. And then the first time you're actually answering it is there. And a number of you had my 105 class or 402 class and 415 classes, and my exams look like, that's the way I do my exams in general. So you can be prepared for that. All right. Last time we were talking about the economic theory of tort law, and what we were saying is, okay, something's happening where you can't really have a contract to bargain, and it's primarily dealing with accidents, right? I don't have time to bargain with you about, oh, you know what, I'm about ready to crash into your car. Is there something that we can do to make this work out so I don't crash into your car? Or I'm swerving off the road, gee, I'd right, if I don't do that, I'm going to run into this buffalo. Is it okay if I graze the side of your car? Right? Can't do that. So we said that what we're trying to do is when if we have low bargaining costs, we could write a contract out about this stuff. But in this case, you can't. The costs of bargaining are too high. So we said, okay, what we're going to do is we want to notice there's some sort of externality in some sense, in that how fast you drive your car affects the probability of me having an accident, right? I mean, if you sort of think about it, it looks a lot like an externality issue here. Again, how fast you drive your car, what happens? That affects the probability of my having an accident. All right? So that's really an externality issue. That is, there's not a mechanism. What's the externalities? When you use your property and affects my property, but the price system can't pick it up. Okay? We're talking about blight. You let your building run down. It affects the value of my building, and there's not a good way for the market to make that happen. Now, so in this case, what are we trying to do? We're trying to get you to internalize that. Right? You want you to internalize the externality, and what does that mean? Basically, we want you to be careful. Right? It's not rocket surgery here, right? We want you to be careful. And what we'd like to have is what? The optimal amount of precaution. I mean, that's what these chapters in tort law are really based on, right? We want you to have the optimal amount of precaution. So, and then what is that going to mean? That is, just sort of thinking about it, you're going to have a cost to precaution, right? Everybody drives 5 miles an hour. There's an opportunity cost to your time, but it reduces the probability you're having an accident, and so we got to figure that out. So, we said that if you are going to, under tort law, I sue you, right? You crash into my car, I sue you, and then I get damages. You're going to have to compensate me for that, right? I can't have an injunction because I can't have an injunction that says you can't crash into my car because we can't really bargain over that, right? When we were talking about why injunctions, when are injunctions an efficient way of doing things? Injunctions work because it assigns a property right, and if there's low transactions costs, I can pay you to not do the injunction, right? And if I can't pay you enough, you'll keep the injunction, okay? So what we're trying to do here is, it says, what do you need to recover damages? So to recover damages, we said there's got to be, and it makes sense that this should be the way, how we structure the thing. But first of all, the plaintiff has to have suffered a harm. We talked about this last time, right? And you can't just say, oh, wow, that was really close, I got scared, etc. you have to have actually caused, there has to actually have been harmed. You have to, when you sue me, you have to show that there's the harm and what was the harm. Second thing is that the defendant act or failure to act, right? You didn't slow down or something. The defendant's act or failure to act caused the harm. Right? So if you're suing me, you have to show that I was the one that actually caused the harm. Okay? And then, so the third thing is this a breach of duty? That is to think about when we're talking about a breach of duty, it is that you have to be careful of other people. I should have been careful of you. Is there something about that says I have to be careful about you? Right? I owe the duty to be careful of you. Now, when we go through here, we'll see that in some cases, strict liability, this doesn't have to come in. Under negligence, then I have to show that you were negligent, right? And so, and that sort of makes sense in terms of the terminology. I was negligent. I owed you, I owed it to you to be careful of what was happening, and I didn't do it. I was reckless driving or something like that. Okay. Under strict liability, that part doesn't come in. All right, and then finally, what we talked about last time was we gave you a little picture of when we were looking at that there was harm. Remember, we had wealth up here, and we had health down here, and we said, okay, this is like a Rod Stewart, every picture tells a story. We drew a picture of that story to sort of show what ought to be happening, and we said you were started out at some indifference curve, and what happened was because of the accident, you ended up on a lower indifference curve. And what are we trying to do? We're trying to get you back to that indifference curve. And we said, if it's possible to get you right back to there, you had an accident, so you ended up down here, you ended up with W1 and H1. If we can get you right back to here, that is, I can pay for your hospital costs and it fixes you and you're back together, then that's what we would do. Let's say you were on a motorcycle and I caused you to have a crash and your leg got taken off. Well, maybe I can't get you back to here. So what would have to happen is I'd have to, if you're stuck at H1, then I'd have to move you back up there. So I'd have to pay for your hospital and your medical expenses, but I'd also have to pay you more in order to get you back to whatever that indifference curve was. And of course, oftentimes the problem then is, how do you measure that, right? How do I know how much I got to compensate you to get you back to the indifference curve that you were on before? And we talked about whether you can have some things like pain and suffering, right? Can that be stuck in there? And of course, what's the problem is then if what's happening is there's uncertainty here about getting you back to U0, right? Again, it's just sort of the logic of the thing. Conceptually, what I ought to do is if I cause you harm, I should be able to get you back to where you were before. And how can we do that? If I can just pay your hospital costs and maybe the opportunity cost that, let's say you were out of work for 2 months, right? I'd have to pay you, what you would have earned during that 2 months. But anyway, I can restore you there. But it may be that trying to figure out what compensation actually is to get you back to U0, that's something that might be hard to do. And we noted last time that in some cases you can be awarded pain and suffering, in some cases you can't, and it depends on the state how like the state of Michigan versus the state of Ohio would affect that. All right, but basically you sort of think about it. What we want to do is, again, we want people to behave in an efficient manner in terms of reducing the chance of the accident. So next thing is, what about cause? Okay, so we talked about harm. And again, what's going on is we're thinking through the conceptual aspect here, what makes sense to do. Actually implementing it may be difficult, right? And we're, again, just like when we were talking about the normative Coase versus the normative Hobbes, should I do something with the law that, if you have an externality, should I do something with the law that makes it easier for you guys to bargain, or should I assume that transaction costs are so high, I should spend a lot of time trying to figure out who values the right more, right? Because if transactions costs are really high, it's going to stick with the person that values the right more. So again, this is a matter of thinking, oh, okay, here's how we ought to do it, but can we add what are some of the problems in actually implementing what the theory would say? So again, that you must have caused the harm, right? If I'm suing you, the injurer must have caused. So if I'm the plaintiff, what do I have to do? I have to show that you caused the harm. The defendant caused the harm. Now, suppose that there's 3 people involved, and you and I were reckless, but you're the one that actually crashed into somebody's car. Okay? The fact that I was equally reckless, but I didn't end up crashing into the car, I'm okay. Okay? You have to show that it's the person that actually caused the harm that is going to be that you're going to sue if you were involved in an accident. So you have to crash into the victim. Now, how do you define cause, right? That is, how do you show that you actually caused the accident? Okay. Now, we can make up stories that it's pretty easy to show, but again, in the theory, we said, okay, what do I want to do? Right? I want to make it so that you take efficient precaution. And what does that mean? I want to make it so that you're weighing the costs of reducing the accident against the expected value of having reduced the accident. So I'm trying to move these things around. So what am I trying to do? I got to show that you caused the accident because I want you to take efficient precaution. But it might be difficult to figure out what actually caused the accident. So there's what we call a cause in fact. In legal terminology, the cause in fact, and what they talk about it in the text is they say what that means a but-for test. And what does that say? That says if your action had not happened, if you had not done your action, then the harm would not have occurred. Okay? If your action or lack of proper action, you owed me this sense of duty here, or lack of proper action, but for that, the accident would not have happened. Okay? So if you hadn't done this, then the accident wouldn't have happened, right? I have to show that, but for your, but for your action, the harm would not have happened, and so so we're trying to show you caused the accident, right? If you hadn't crashed into me, my car wouldn't have been damaged. Okay, I wouldn't have gone to the hospital, whatever. So I mean that might be in some in a lot of things that might be obvious, but some cases it might not be, right? I'm saying, yeah, the accident happened, but it really, I wasn't really the cause. That the reason that you got lung cancer was not because of secondhand smoke from me, because you would have got lung cancer anyway, right? Or you were, you were driving fast on the turn and you would have crashed anyway. No matter, whether I was there or wasn't there, you would have crashed anyway. That would be my defense. Okay? So you have to show that, again, this person's action, if I'm suing you, I have to show that the person's action actually caused the accident. If they hadn't done this, if they had not done that, then the accident wouldn't have happened. Okay? Then sort of think about it. What if there are multiple causes? So what if there are multiple causes? And again, it's sort of thinking through what we're doing is we're saying, okay, I can lay out the theory. It says, okay, this is obvious. Shows the person harmed the other person, and so you established harm, but how do I measure what that is, right? I'm going to compensate them. How do I measure that is? Okay, then we say, oh, okay, we have to show that the person caused the accident, okay? Well, what if it, they were there, this thing happened, but but if they hadn't been there, or if they hadn't done this, would the accident have happened, right? So you got to show that they actually caused it. Then we're talking about, well, what if there was multiple causes, okay? So for example, what if you smoke and you work in a coal mine and you end up getting lung cancer. Okay? So you sue the coal mining company. Right? You get lung cancer. So you get lung cancer, and what do? You sue the coal mining company. Well, what's their defense going to be, right? If there's all sorts of things that could have happened that caused it, they're going to say, well, wait a minute, you've been smoking 2 packs of cigarettes for the last 10 years, right? You're the one, it was your smoking that caused it, not the fact that you were working in the coal mine, right? So if there's multiple causes, then you got to figure out, okay, what was the thing that was most likely to do it? Or we could make it that you could sue both, right? You could sue the cigarette manufacturer because they didn't put on the package of cigarettes, this can cause lung cancer or something like that, right? So if there's multiple causes, you could make it so that you can sue each of the parties that was involved in the cause of action, right? Or you could make it that you can only sue one of them, right? You can sue the one that that's most likely to have caused the accident or most likely to have caused the problem. Okay? So again, there's lots of ways to formulate the law. what are you trying to do? You're trying to make it so that people take efficient precaution. So how you structure the law may depend on the individual circumstance. And it can be different in some states than it is in others. Again, it's just a matter of thinking through what you're trying to do with the law. What if there were a chain of events that caused it? Again, these are problems in trying to figure out the actual cause, right? What if one person does this, this caused this other thing to happen, this caused this other thing to happen, okay? So I got a deer runs out in front of a deer runs out in front of a truck, okay? The truck slams on its brakes, right? And the truck was, let's say, speeding by, 5 miles an hour over the speed limit, right? The deer runs out, the truck slams on its brakes, you're coming along, you're almost going to hit the truck, you swerve into the other lane. When you swerve into the other lane, what happens? You crash into somebody over there, okay? Who caused it, right? Who caused the accident? When there's a chain of events, you got to start to work through. But if you work through back far enough, you could say, well, you know what? If you had never been born, then this wouldn't have happened, right? If you had not been born, you wouldn't have been in the car, and therefore, the car wouldn't have swerved and crashed into whatever, right? So if there's a chain of events, you gotta, how far back do you want to go? Do you want to be able to sue all the people that are involved in the chain of events? How far back can you go, right? And if you sort of think about that, suppose that the second person in the chain of events is super wealthy, okay? And, when you sue them, what do you got to think through? We were, talking about expected values of things, right? And I got to determine if I sue somebody, I got to think through what's the probability that I'm going to win the suit, right? But one of the things you got to think about, what's the probability they can pay? You sue me for $5 billion. The market's down a little bit today, so I might not be able to pay the whole $5 billion, okay? But, if you sue somebody that isn't capable of making the payment back, then what's the value in that, right? So you'll have spent money hiring an attorney, and you win the suit, and then the person can't pay back. So now you're looking at it, okay, the driver of the truck doesn't have a lot of money, but the people driving the Mercedes that swerved to avoid the truck and crashed into you, right? They've got lots of money. So how should I be able to sue any of the parties in the chain of events? And then how far back can you go, right? So can I sue everyone in the chain? And how far back? There's an idea of what's called proximate cause. And proximate cause says that, okay, you have to be close to the chain. And again, how strict do you want to make that? The Mercedes crashes into your car, they actually, they were proximate cause, right? But the truck driver affected why the Mercedes crashed into your car. How close do you have to be in that chain of events? The actual crash occurred because the Mercedes crashed into your car, right? What caused the Mercedes to crash into your car was the slowing down of the truck. So do I want, do I say, you had to be the proximate cause. It was the person that actually crashed into it. Or do you want to allow to move back the chain of events? So now you can sue both parties. Okay? Again, if you're thinking through the incentives, if you make it so that the Mercedes is going to be liable if they crash into it, guess what? They won't follow so close to the truck, right? If the truck can be sued as well, if the truck driver could be sued as well, what's the incentives, right? They won't speed when they're driving down US 12, right? They'll go slowly in case a deer comes out. Because even if they don't crash into your car, they might cause somebody behind to crash into your car. So how you write the law really depends on thinking through the incentives of the system. And that's what this whole thing's about, right? Trying to set up proper incentives for you guys to take, optimal precaution. And again, like I said, it's like it's internalizing this externality of how you're driving your vehicle is affecting what's going to happen to me as I'm driving down US 12 on the other side of the road. And I want you to take into account that you can cause damage to me. I can have something happen to my car if you crash into it. All right. What about this last piece that we talked about, which is breach of duty? So breach of duty is saying, okay, did you owe me something as a duty? That is, did you owe me that you shouldn't be careless, right? You owe me the, I'm driving down US 12 and you owe me the duty to not drive recklessly and bang into, increase the probability you're going to bang into my car, okay? If we look at a thing called strict liability, under strict liability, then it doesn't require a breach. It doesn't require me to show that you had a breach of duty. Okay? When I'm suing you, I sue you under strict liability. I sue you. I don't have to show a breach of duty. Okay? I don't have to show you were careless or reckless or something else, that somehow your crash happened because you violated your duty to be careful about what's going to happen to my car. Okay? All I got to do under strict liability, all I got to do is show the first two parts, right? That there was harm to me and that you're the one that caused the harm. Again, lots of issues in doing that, right? We were just talking about, are you the proximate cause, and what about the if there was more than one person involved in the accident, etc. Okay, so if there's strict liability, oftentimes strict liability is about something that's inherently dangerous. Usually that's when you have strict liability, okay? That is, I don't have to show that you were careless. This is something that, hey, let's say you are, you're using dynamite to blow stuff up, okay? You're building a road or something, and what you have to do is you have to use dynamite to cause this explosion, okay? That's an inherently dangerous thing. And what do we want you to do? Again, we want you to be careful, right? We want you to take efficient precaution. So if something's inherently dangerous, we're going to say, you know what? We don't have to show that somehow you were negligent in doing it. I don't have to show that. All I got to say is, hey, you going to use dynamite to do this thing. If you cause damage to somebody, guess what? You're going to have to pay for it, right? If they can show that you were the thing that caused it, and whatever the harm happened to them, then you're going to have to be careful of it. So anything that's inherently dangerous, like like I said, dynamite use. You keep wild animals on your property, right? You keep wild animals on your property. Guess what? I don't have to show that. I don't have to show a breach of duty. Your animals running around is, you got lions or something. You've got let's say you have a game hunting place, right? So people come, you got 10,000 acres down in Texas or something, and people hunt wild animals on it. Okay, if that's what you're going to do, then if that lion gets loose, I don't have to show that you were negligent somehow in letting that lion get loose. You're keeping lions on your property, guess what? That lion gets out, you're going to be liable, right? So if you have strict liability, then I don't have to show that you were reckless or something like that. Whatever happens, you know that when you decide to keep lions on your property, you know that if that lion gets out, all I got to do is show the lion bit me, and here's how much the harm was. Okay. The other option is to show negligence, right? So under negligence, that's showing there was a breach of duty. That is, you were negligent in what you did. Okay? I have to show that you had a duty not to place me in this situation, and you failed to do it. So, how do I show that people were negligent? Well, what I got to show is, hey, you should have been more careful, right? That you owed me the responsibility to be careful about whether there's an accident going to happen. Okay. So what would happen is that if I'm the defendant, the defendant has to show that, right? How could the defendant show they were not negligent? Let's think just what's sort of an obvious thing that we would look at. Let's say driving your car. Okay. If we're structuring this law, now in the suit, we've required the demonstration of negligence for this whole thing to work, right? So what's that going to do? There's going to be a cost to the court system to figure out whether you were negligent or not, right? We'd like to make that an easy thing to do, okay? So let's say we're talking about driving your car around. What would we make a rule that said, you know what, this makes it clear that you weren't negligent? What would you do? We'd say, if you're driving your car, drive on US 12. What are you going to see? There's going to be a sign. Yeah, a speed limit, right? I mean, if we said, you know what, here's how the law is going to be. If you were driving the speed limit, then you're not negligent. If you were driving faster than the speed limit, you're negligent. So I don't have to show, gee, were you negligent or not, right? We're going to set some standard. So right? So example, speed limit. If you were, what we would make it that, you know what? So what does that require us to do? That requires us to figure out what the speed limit ought to be, right? And of course the speed limit differs in different places. 70 miles an hour on I-94, 55 miles an hour on US 12. So when we were making what the speed limit was, theoretically, how would you set the speed limit, right? You'd set the speed limit so that it's going to be an opportunity cost of people's time. Drive out to New Buffalo, out on the, anybody ever, how many have been to New Buffalo? Just one of you? Okay, yeah. Well, anyway, New Buffalo's out at the end of US 12 on Lake Michigan, okay? So you can drive US 12 and it's a lot closer than if you drive up to 94 and take 94 around, right? And then get on to 80-90, and or I guess you don't even get to 80-90 and to get to New Buffalo. I guess you can get off on 94 and 12 and jump on there, okay? A lot farther to go that way, but if you do Google Maps, what's it going to do? To reduce your time, you're going to end up going up to 94, okay? Because US 12 is 55 all the way. So what's going on, right? There's an opportunity cost of people's time to drive at 55. So we have to weigh that against the reduction in the probability of an accident, the expected value of an accident, okay? And so how do I figure out what the speed limit is? Theoretically, we can say, set the speed limit, right? That reduces these transactions costs of when we're in the suit to have to show that this person's negligent, or for you in your defense to show that you weren't negligent. And so I got to now figure out, what should that be? How to figure out what that speed limit is going to be. What's another thing? Industry standards. Okay? If I have an industry standard that you're making cars, and the industry standard is to have an anti-lock brake system, okay? Then you can't sue me as the Ford Motor Company and say, they should have made the brakes better so that my car wouldn't have had to swerve in order to keep from crashing into the truck, right? Or did this fireplace, you got this natural gas fireplace instead of a regular wood fireplace. So you buy this natural gas fireplace, and then what happens? Something happens, the gas leaks, and the house catches on fire, or you get some illness from smelling the natural gas or something. What I got to do is say, oh no, okay, I'm not negligent because this is I actually met the standard, the industry standards. So industry standards are another way of reducing the transactions costs in the sense of when the suit's going on to show whether you're negligent or not. Notice that even though you have a speed limit, you've probably heard about this, driving too fast for conditions. Right? When you're driving down US 12, I don't know if you've ever been in Michigan when there was fog. Okay, right? It can get pretty foggy at times, right? Like our political system. But if it can get really foggy, and so you're driving down US 12 and the speed limit's 55, but you can only see 3 feet in front of you, right? If you're going 55 and then you run into me because I'm going 35 because I can't see, and you crash into me, okay, I might be able to say, hey, you caused the crash. If not for your actions, the crash wouldn't have happened. Here's the harm to me. My car got damaged. But if it's not strict liability, then I have to show that that you had a breach of duty to be going slower, and you can't use, in that case, you couldn't just use, hey, I'm meeting the speed limit, right? You were driving too fast for conditions. So again, there's ways to implement what the theory is, and that's what we're you have to think through what the different problems are and how should the law look, because again, what are you trying to do? All right, so we're coming into the next section here, which is the economic theory of tort liability. So I think what we'll do is we'll just go ahead and stop here. Again, we'll have the exam on Monday. Wednesday, we will start talking about the economic theory of tort liability, and then then we'll have the break and come back on Monday. So you'll probably want to study for the exam for Monday, focus on that. But once the exam's over, then go ahead and just basically work your way through chapter 6. Is what we're doing is working our way through that, and the next section again is the economic theory of tort liability. All right.